Court of Appeals, Division 1 is now in session.
Thank you. Please be seated. Good morning. This is the time set for oral argument in our cause number CV140024, Wilson versus PNC Mortgage et al. Counsel, we are recording today's proceedings, so when you step to the podium, if you would please state your name and the client that you represent. Each side will have 20 minutes for argument, and appellant's counsel will be responsible for watching the clock and reserving any time for rebuttal that you may desire. We've read the briefs. We've conferenced the case prior to the argument. We think we understand the procedural, factual history and the legal issues. And with those preliminaries out of the way, counsel for the appellant, you may proceed.
Thank you, Your Honor. Good morning, and may it please the Court, John Kerkorian and Bo Roysden on behalf of the appellant PNC. I would like to reserve 5 minutes of my time, Your Honor, for rebuttal. And I'd like to begin with the question that the Court raised in its order last week. Specifically, the Court asked whether PNC had preserved for appeal the argument that plaintiff cannot prove breach of the covenant of good faith and fair dealing in the 2006, arising out of the 2006 loan modification, out of the 2006 agreement with respect to loan modification. That was the Court's question. We did preserve that argument, Your Honors. We issued or presented a oral motion for judgment as a matter of law on June 19th, 2013 at pages 13 and 14 of the trial transcript. At the close of plaintiff's case, plaintiffs argued to the Court that the validity of the proposed loan modification was irrelevant to the question of good faith and fair dealing arising out of the 2006 agreement. And PNC orally moved for judgment as a matter of law on that issue. We believe that...
This is pages 13, 14 of the June 19 transcript?
Correct, Your Honor.
Okay.
We believe that that oral motion preserved the issue for this appeal. And substantively and as a matter of law, that is a legal question. The scope of the duty of good faith and fair dealing arising out of the 2006 loan agreement is a question of law for the Court. The purpose of the covenant of good faith and fair dealing is to prevent a party to the contract from depriving the other of the benefits of that agreement. In other words, the scope, the parameters of the covenant of good faith and fair dealing are circumscribed by the obligations contained within the agreement itself. With respect to the 2006 loan agreement, the obligations were that plaintiff would repay the bank at a specified interest rate over a specified period of time.
May I go back to one point? And I'm
Yes, Your
sorry,
Honor.
because I was checking the transcript pages on the oral argument point. The motion for directed verdict, which we know is no longer the appropriate lingo, but nevertheless, your colleague made it. But the Court understood it to be under count 1, which was breach of the original loan agreement, not under count 3, which was the implied covenant count.
I don't think that's correct, Your Honor.
I've got it right here. Thank you. There is sufficient evidence to go forward. The motion for directed verdict is denied on count 1.
Well, Your Honor, but
Okay.
prior to that, there was discussion about this very issue, the covenant of good faith and fair dealing arising from the 2006 loan agreement.
So that's the preservation of the record. There
Yes.
isn't any. It isn't anywhere else, though.
That is correct, Your Honor.
Okay.
Yes.
Okay.
But
I'm
it is-
sorry for the interruption.
That's okay.
Please.
Fundamentally, it is a legal issue, and because it's a legal issue and not a sufficiency of the evidence issue, it's appropriate and preserved for this Court to determine what the scope, what the legal duty is arising out of the 2006 loan agreement. And as I was saying, the duties are circumscribed by the actual obligations of that contract. The duty
Well,
of
there's
good
no
faith.
question that under the 2006 loan agreement, the bank was not under any obligation to extend a modification.
Correct.
Or to even, I don't think, negotiate one.
Correct.
But weren't there duties, didn't the bank have obligations when it wanted to go forward with a foreclosure? Specifically, the record reflects that the bank sent a letter, I think it's October the 6th, explaining that the Wilsons were in foreclosure because of the bank's mistake or an error. Given that the foreclosure was, the bank had triggered their foreclosure and gone forward because of the bank's error, then the deed of trust required, isn't there an argument that the deed of trust then required the bank to re-notice the default and to give the Wilsons an opportunity to cure it before pursuing a foreclosure that had been triggered based on the bank's own mistake?
Well, Your Honor, in this particular case, there was no foreclosure. The bank did not foreclose.
I understand that, but the issue here is breach of the implied covenant. The facts that I just related, couldn't a reasonable jury find that based on those facts, the bank breached the implied covenant of good faith and fair dealing under the original loan agreement?
I think we have to go back to the agreements, the deed of trust and the loan agreement.
Right.
And there, again, there's no question that under the deed of trust and the original loan agreement that the bank, that the borrowers were not making the required payments.
That's right, but in order to go forward with a foreclosure, I believe it's paragraph 22, but it's around in that deed of, around there in the deed of trust. In order to go forward with foreclosure, specifically to accelerate and then go forward with the foreclosure, the bank had to provide notice of a default and provide the Wilsons with 30 days to cure the default. Here, the only reason why the foreclosure had been triggered was because of a mistake and an error, a self-acknowledged error by the bank. Given that, before the bank could go into a foreclosure, didn't it need to then follow the deed of trust, the requirements of the deed of trust before invoking the power of sale?
Your Honor, I think it could, but in this particular case, there was no action taken to foreclose. There was a notice, and there was an invalid loan modification agreement.
You know, I think maybe we're segueing into the damage issue, and that's close. But don't you think that someone who's you have a jury of 12 tried and true good people, and they see that there is a foreclosure pending against a couple for months with the uncertainty and the stress that brings based on a error made by the bank? Don't you think that that would have given a jury at least enough evidence to find, that's all we're concerned about here, is whether there's sufficient evidence to find that the bank could have breached the implied covenant of good faith and fair dealing under the original agreement?
Now, if you look at the conduct following the acknowledgement of the error, the bank immediately went to the plaintiffs and said, here's the agreement that we really should have entered into in the first place. And that's where things fell apart, and that's where the plaintiffs immediately went into court. So I think on those facts, we don't have breach of the covenant of good faith and fair dealing here. But let me turn to the court's question about damages, because I think...
Well, I know we're jumping around, but isn't there a predicate question about whether there's a contract at all, an enforceable contract at all, from which a breach of the covenant could flow?
Well, if I understood the court's question, the question from the court was whether the 2006 loan agreement could give rise to a breach of the covenant.
No, I completely understand your colloquy with Judge Norris, but do we have to go down that path? Doesn't that whole analysis hinge on what the threshold issue is about the statute of frauds?
Well, I believe it does. I mean, the enforceability of the 2006, of the loan modification, let me start over. The enforceability of the modified loan is critical to both contract damages and breach of the covenant of good faith and fair dealing. If there is no valid modified loan, then we don't get to damages under either theory for the modification.
And can you just give me the Cliff Notes version of why partial performance doesn't take this outside the statute of frauds?
Well, because the plaintiffs asked only for a legal remedy.
Ultimately, they withdrew the special or the specific performance?
They asked for specific performance and ultimately elected not to pursue that. And
that rendered the partial performance doctrine obsolete or
correct. I mean,
inapplicable.
I think the cases are clear that where a party is only pursuing its legal remedies, only money damages, that partial performance is not implicated in the statute of frauds analysis.
Thank you.
I do want to just, I'm running out of time here, of course, but I do want to talk about damages because I think regardless of whether the court finds that there could be a breach of the covenant of good faith and fair dealing arising out of the 06 agreement, or that there's a valid loan modification, which I think there are serious questions about. Regardless, the plaintiffs failed to prove compensatory damages. They failed to prove the fact of damage because their entire case was, by their own admission, dependent upon an event, the foreclosure, that had not occurred. It was undisputed at the time of trial that it had not occurred. It still has not occurred. And I believe the record shows that the plaintiff said, if there's no foreclosure, then I have no damage. So the jury was asked to assume that the foreclosure would occur, and that is improper. That's not the purview of a jury, and so the fact of damage was not established. Equally fundamental, there's a real problem with the measure of damage. Contract damages, as the court knows, are designed to put the non-breaching party in the position they would have been but for the breach. The benefit of the bargain damages. There was no evidence presented in this case about lost benefit of any bargain. What might have been valid contract damages had they been had this evidence come in or been presented, and had the foreclosure occurred, valid contract damages could have been the lost equity in the home. That might have been valid contract damage. Another valid contract damage might have been the difference between what plaintiff claimed they were promised, the lower payment amount, and what they got stuck with either through PNC or another loan. Again, no evidence of that. Instead, what the plaintiffs asked for and what they received was reimbursement for payments they were contractually obligated to make prior to the time of the breach. That's not, under any measure, valid contract expectancy damage. So on that basis alone, we believe the jury's verdict has to be reversed. I want to touch on special relationship and the tortious breach of contract claim as well. There was no special relationship here. This is a garden variety lender-borrower relationship. And to examine tortious breach, you have to look at the contractual relationship. Again, PNC lent money. It had performed its duty under the contract, and it was just monitoring, making sure it was tracking the payments. That was what flows out of the 2006 contractual relationship. Plaintiffs promised to pay, and there was a security interest involved. No case that we're aware of finds a special relationship in that context. The only cases involving a bank where a special relationship is found is either where the bank acts as a financial advisor over decades, or enters into a separate agreement, like in the Thomas case where there was an escrow agreement that had been established in connection with the loan. We don't have those facts here, and so there's no special relationship. The tortious breach count should have never been presented to the jury, and that would also take away the punitive damages case. By the way, we just briefly, we do not believe that the plaintiffs met their burden in proving by clear and convincing evidence the standards that need to be met for punitive damages. So with that, unless the court has any other questions, I'll reserve. Thank you.
Thank you.
Good morning. May it please the court. My name is Veronica Manolio. I represent the Wilsons, who are the appellees and also are here in the courtroom. I would like to start where Mr. Krikorian started, in the same place, and let you know the issue regarding the covenant of good faith and fair dealing on the original loan agreement is not an issue that PNC preserved. How do you know? Judge Norris asked the question very pointedly, and I encourage you to go back to the transcript. We also know because to protect themselves, PNC, in writing, renewed each of the motions it filed orally as directed verdicts. It renewed those motions as motions for judgment as a matter of law in writing, to which the court allowed additional oral argument and responded to after a weekend and 2 days to consider them, and made lengthy rulings. They're in the trial transcript. I've put them in my appendices, at appendices B and C. PNC then renewed its motions, which it properly did to preserve each and every issue it wanted to bring here on appeal. And again, it argued the covenant of good faith and fair dealing, but not distinct between the two loan agreements. And how do we know that it didn't distinguish? Because PNC did a really good job in the joint pretrial. If you go back to the joint pretrial, and it's number 91 in the record, in the joint pretrial, they said, wait, you have a breach of contract claim, but there's two distinct contracts. You're saying that we breached the original loan, and you're saying we breached the loan modification. You have to distinguish your two contract claims, and you have to instruct the jury. And the judge agreed with them, and they were right. That happened before we even opened, because I opened explaining to the jury that we were going to argue breach of two separate contracts. The verdict form had two separate contracts. The jury was instructed as to two separate contracts. PNC never argued with regard to the covenant of good faith and fair dealing that there were two separate contracts at issue. It was couched in terms of the contractual relationship between the parties. Now, aside from the fact that I believe they did not properly preserve a distinction between the two, it doesn't matter. Because as the court noted this morning, I understand Arizona law says the bank did not have a duty to give a modification. That was not the basis of my breach of contract claim in the first instance. It was when the bank agreed to give a modification, and it granted a loan modification. It breached the spirit and the intent of the original loan by not acting in good faith when it made mistakes. So what it did is it said, we offered you a loan modification, we accepted it. We believed there was a modification in place. When we realized we made an error, we believe we get to scrap it, throw the original loan back in place, and put you out on the street. I heard Mr. Krikorian say this morning, well, but what we did after that was good faith, because we offered another modification. The distinct fact in this case, and why this case qualifies for a tortious breach, not just a breach of the covenant of good faith, but a tortious breach, is that the bank chose to keep that trustee sale hanging over these people's heads, not for, as you noted, months of stress, years.
Well, I don't want to take you off your game plan too much.
No problem.
But in what you've said, there are three predicate issues.
Sure.
A, there is the statute of frauds issue. But more importantly, there is the damage issue, or lack thereof. And then third, there is the whole issue, before you even get to any tortious breach of the implied covenant, there has to be a special relationship. Mm-hmm. And Mr. Krikorian has made both today and in writing, a very strong case that under these facts, there just wasn't a special relationship.
I agree. He's made those arguments very well in writing and orally, but he doesn't make them supported by the record.
Well,
and the evidence.
We've read the record
Okay.
pretty closely. And Mr. Brown negotiated or discussed loan modification terms with Mr. and Mrs. Wilson, and the Wilsons understood that he was working for his employer, but there's no evidence of any type of fiduciary duty here.
I would agree with you that I don't think, and I'm not asking this court to draw a bright line rule, that every loan negotiator creates a fiduciary relationship. Wouldn't even suggest that that's the way to go.
Right, okay.
I am suggesting that there are certain cases with facts, like Thomas, where the bank became an escrow agent, like this case, where Mr. Brown stepped in the shoes. They had hired a negotiator. He stepped in the shoes and said, "You have been mistreated. I am going to take control of this file and get you a full-blown
But
modification."
when does a bank employee's apology for a boodle of mistakes, I think it's fair to say,
Yes.
somehow create a special relationship, thus imposing the bank to possible punitive damages? I mean, business people make mistakes every day of the week, and they expect their employees to do the right thing and to apologize, and that clearly happened here. But I'm just not seeing anything else under our case law that suggests there was any type of relationship that went beyond an acknowledgement of errors.
And I can appreciate that suggestion, Your Honor. However, let me explain to you, we're aiming at way more than just the apology. It was not just the apology. Here's what happened, and here's what the trial evidence showed. I'm again going to ask you to look at trial exhibits 76 and 81. They're in my appendices I and J. What Mr. Brown did is, the very month that my clients qualified for their loan modification, or got the original trial payment in place, which is back in 2009, PNC takes over from the predecessor bank, which was National City. They have massive, and their witness is the one who said it at trial, they have massive mix-up in the merging of the banks. The bank, PNC, did not even recognize that there was a loan modification in place. So in February of the following year, they throw them into foreclosure, send back the payments they've made under the trial modification that they agreed was in place. The bank then says, "We're going to assign a specific person to your file. This is Desmond Brown. Here's his personal number." They negotiate solely with him. Miss Wilson indicates to him, "We have a negotiator, a third party." She's noted as authorized other. He says, "I'll work with you personally." They take their own negotiator out of the loop.
You know, I will tell you, the bank's notes, which are not necessarily a paradigm of easy reading, do suggest that bank employees had conversations with the Wilsons' third-party negotiator subsequent to that, after that.
I agree with you. And if you look at the final notes, if you look in Exhibit 76 in the loss mitigation notes, look at SWO, that's Desmond Brown. He says, "I called Madeline Joseph to let her know what I was able to negotiate for the Wilsons." If you also look, when he first made the mistakes, and he said, "I made a mistake, I told you I was giving you a step rate interest rate, I went and I put a fixed rate in the computer by accident." He says, "I went to my supervisor and asked to get approval, and the supervisor gave approval outside of an investor approval because, quote unquote, we are delegated." At trial, there was absolute testimony, again in the record in my appendices, from their representative that said, "We gave this a special case because it didn't need an investor approval. Delegated means we, the bank, have authority. We don't need an investor to sign off on it. They've given us delegated authority to make decisions." So Desmond Brown negotiated outside of the realm of what he did because he made a mistake, taking her authorized other, her negotiator, out of the process and putting himself in the shoes of helping her get a better deal. I agree those are facts that don't happen in the normal case. I agree that's not a typical bank employee. Then if you look at the notes after he does it, on June 29th, once he's negotiated, he calls her home on an evening to check in, see how she is, and make sure she's happy with the resolution. I don't know about you, but I've never had a bank call me to say, "Hey, I'm really sorry
Well,
about
I've had
everything."
bankers call me, but perhaps for not.
Yeah, and they're never calling me to help. I do want to go back because you posed 3 separate issues to me. I think that one does address why I think there's a special relationship. I also would like you to understand part of the special relationship and what we found so odd was the briefing seems to suggest there was insufficient trial evidence. We begged Desmond Brown to come to trial. Tell us why Miss Wilson's version of the events, that she relied on you, that she trusted you, that she thought you were going to bat for her, she felt you negotiated for her, and she was relying on you as quote-unquote her hero as her husband's going through cancer. Why is she wrong? They chose not to bring Desmond Brown to trial.
You say you begged him. Did you subpoena him?
I tried. They said, if you subpoena him, we're going to file sanctions. I was 1 month into the case. I think you probably read that.
I think it's, to be fair, it's a little more complicated than that, but the bank is under no obligations. Maybe they should have brought him, I don't know, but they are under no obligations to bring a witness.
I agree, but then you don't get to complain about the insufficiency of evidence. They had every opportunity to rebut what Miss Wilson believed the relationship was. They chose not to, and the one witness they brought said she had zero interaction with this file until she was appointed as the representative for the lawsuit. I do want to address the statute of frauds because it's important and it's a legal issue. And it's a legal issue that they've lost on 3 motions with the trial court. And for good reason, this court should also uphold that it's not applicable here. Arizona law is clear that in a borrower-lender relationship on a mortgage, on a property, it is the mortgagee, the person borrowing the money, that is the party to be charged.
That is absolutely correct when it comes to the enforcement of the mortgage, but this is not that case. This is a case involving the Wilsons' effort to enforce, at least in part, an oral modification. And so they are the party seeking enforcement. Under the Passy case, the party to be charged here then would be the bank.
I agree that that was a distinction, but it is not a bright line rule that in a loan modification the bank has to countersign. In fact, the case that they cited, Snyder, out of the district court, stands for the exact opposite proposition. They cite it to you and told you that that case was dismissed by the district court because of that.
We're not bound by what the federal courts do, despite what the federal courts may think. We apply Arizona law, and nevertheless, under the statute of frauds, the agreement has to be signed by the party to be charged. The bank didn't sign it.
I agree with you, they didn't sign it. But, again, this goes hand in hand with what is the purpose of the statute of frauds. It's so that people cannot be defrauded. I would like this court to seriously consider this. If you look at the loss mitigation notes, again, Exhibit 76, what happened in this case is the bank did not fail to sign it for the reason they said. The bank found out it made an error. The bank found out Desmond Brown put the wrong interest rate in. Then they had Mr. Desmond Brown write a letter dated October 6th, which is Appendix M, my appendices. They had him write a letter and say, our investor won't let us countersign, therefore it's not valid. We can't get approval. We know from trial evidence that is untruthful. I won't use a bad word.
I noted that in your briefing, that it seemed like you were making an argument that there is an additional exception to the statute of frauds, not part performance, but a party's fraud. Is that what you're saying?
I'm saying it defies the entire purpose of the statute of frauds.
Well, the problem is I didn't see any authority supporting that, and that's not an argument I think that was fairly raised in the trial court.
And the reason, Your Honor, is because, I did argue it, and I think I fairly briefed it, that the purpose of the statute of frauds is we don't want parties entering contracts that cannot be performed and then saying, oh, but I did not sign it. I believe in this instance that the party to be charged is still the Wilsons. The Wilsons are the party that owes money. If the bank later finds a buyer that could pay more money, they can't refuse to countersign and say, well, we can probably get a better deal. In that instance, it doesn't matter what the reason is for not countersigning.
But assuming you lose on that point.
Sure.
Here the bank is the party to be charged. They didn't sign it. What authority stands for the proposition that we can carve out some other exception to the statute of frauds? What authority is that, legal authority, not just your belief that it's unfair?
Oh, I appreciate that. I don't believe that the party to be charged is right. So I think that I don't have another legal authority that says there's an exception. I think it violates the actual purpose of the statute of frauds, which is to protect people like the Wilsons.
Isn't there also
whoever.
a problem in withdrawing the specific performance demand in terms of your part performance argument?
I did not make a part performance argument at trial.
Are you making it now?
I'm not.
Okay.
I am not arguing that part performance gets me around the statute of frauds exception. Never argued it below, not arguing it now. Because Mr. Krikorian is right, I had to elect a remedy when we went to jury, and I elected a money remedy. So we did not. I do want to get to the issue of damages. I know my time is running short. Let me tell you the very easy thing. We never asked the jury to speculate. The bank in no uncertain terms made it clear they own this house because of the original deed. The bank in no uncertain terms has made it clear a trustee sale will be conducted when it wishes to do so. How do we know that? They never, ever stopped the foreclosure. The Wilsons absolutely put on evidence of damages that were not speculative.
But there is forgive me, there's a
Sure.
fundamental disconnect here. This foreclosure, or a foreclosure, has not happened. If the bank had pursued foreclosure and had sold the property, the Wilsons would have quantifiable damages. It just didn't happen. And in a sense, it seems to me what the Wilsons are trying to do is to shoehorn themselves into a theory, basically, that Arizona has not yet adopted, which is wrongful foreclosure, and a measure of damages, and other states have, without, in fact, having lost the property. It wasn't ripe yet. Damages were not ripe in this case.
Two things. Number one, again, I inherited the case a month before
I
trial.
understand, and I appreciate that.
Issue was preserved and preserved and preserved, and no pretrial motion was ever filed to have that fleshed out. We get to trials
On
of
damages, I think the bank did move.
No, they moved to preclude evidence.
That's true.
They did
Okay.
not move for summary judgment. They did not move, and they had an expert witness who was an economist, a money guy, who never talked about the measure. He just talked about his own calculations of the loan modification. The issue here is the Wilsons said 100%. We understand if we receive money damages, that bank or that house belongs to the bank. We don't get both. We understand we don't get both, but this is how we measure our damages. Our jury,
Go back, because it's
Sure.
not the measure of damages that I hear Judge Norris asking about, although that's possibly part of it, but it's the fact of damages.
I get it. And this is the part of this case that makes this case so unique. What do you do with a bank who, as I talked about at trial, was the proverbial big brother sitting in the back seat saying, I'm not touching you, I'm not touching you, I'm not touching you. Can't get in trouble because he hasn't poked you.
Don't you pursue specific performance?
Indeed, that was an option.
That's exactly what you do when your damages are possibly not ripe, is you pursue specific performance, don't you?
Indeed, that was an option.
Right.
But to ask for that at the last moment when we were to make a decision, we elected to ask for money damages.
Well, but if you don't have certainty of damages, which is a requirement, there's more give in the joints when it comes to the measure. But damages have a level of certainty, and here they're based on an event that just had not happened.
However, the bank undoubtedly and repeatedly kept telling that jury that we have the right, because we never had to even give them a loan modification, we have the right to foreclose. We have the right to take that house back. We have the right, and just haven't chosen to do so.
But forgive me.
Sure.
And I don't mean to beat this into death. The struggle I'm having here, and I want you to understand it so that you can help address it, is there was a remedy, a possible remedy. The remedy was specific performance. And that would have avoided all of the issues with damages. It would have avoided the statute of frauds, arguably. And so there were options here.
I completely understand the point. I don't understand at any point how the judge could have stepped in and ordered specific performance with the evidence that she had in front of her when the bank was saying this loan modification that we offered isn't even a loan modification. This isn't even a contract because we messed up and it has inherently inconsistent terms. So it could never, ever be performed And you, Judge, will never, ever be able to reconcile the terms because we don't even know what we offered. And I tried to elicit testimony from the bank's representative. What were the terms the bank was offering? I don't know. Who from the bank could tell me? I don't know. What is your part in this case? To talk about the notes and the documents. How will we ever know what the bank intended? I don't know. How can I ask a judge to order specific
Well, but you
performance?
took the position that Exhibit 21, which was the third proposed loan modification, was in fact the enforceable loan modification. I mean, that's the horse you rode at trial.
Absolutely. And we told the jury that our client believed the material terms included the payment amount at whatever the interest rate was that Des and Brown put in the computer. And that's what the jury absolutely awarded. Thank you.
Thank you. Rebuttal, Mr. Fran?
Just very briefly, Your Honors, on the issue of preservation, we do think the oral motion preserved it, and just want to draw the court's attention to the Lyristis versus American Family Insurance case, very similar to this case.
Would you give us the site?
Sure. It's 204 Arizona 140. Very similar to this case where there had been significant discussion and briefing and the issues had been raised, and it was fundamentally a legal issue that the court can address. And for the reasons I've discussed earlier, we think the parameters of the covenant of good faith and fair dealing arising out of the 06 agreement are for the court. On the issue of special relationship, I appreciate the facts and counsel's version of what happened at trial, but really don't think that they have any bearing on the issue of whether there was a special relationship. It's the character of the relationship that is at issue. And here, there was nothing that changed the relationship of these parties between as lender and borrower. With that, I'm happy to answer any questions. Thank you.
Thank you both for your presentations. We will take this matter under advisement and issue a ruling in due course. At this time, we will stand in recess in preparation for our next argument. Thank you.